Hi, I'm Betsy Urbance, Chief Legal Counsel at Illinois Realtors, and joining me today will be Annalise Fierstos, our legal hotline attorney, and we will present to you episode 3, which is entitled Licensing and Management, or as I like to call it, Education and Oversight. The first point with regard to licensing and education, there are some new terms under this act. Globally, leasing agent, as it was formerly known, is now residential leasing agent, which was an initiative of the department and really makes sense that it clarifies that a leasing agent can only do those activities that have to do with residential leasing and not sales and not commercial leasing. So no sales of any kind and no commercial leasing, but residential leasing. Makes sense, right? The other term that was changed and is now a defined term under the Act is designated managing broker. And as you've heard in prior or subsequent episodes, that designated managing broker is the person that's in charge of an office.
With the changes that Betsy Urbance just discussed, there have been changes with the continuing education requirements for residential leasing agents. Now, under Section 5-10D, residential leasing agents need 8 hours per cycle, and there have been changes to the classes that are required. Now, there are classes required in fair housing in residential context, advertising and marketing, lease and applications, credit reports, and criminal history, handling money, owner-tenant laws and relationships, and environmental issues. For broker licensees, there have been some changes with the requirements. There is an age change. You can now be 18 years old. With age change and input from the industry, it has been determined that broker agents need more hands-on and real-life situation training, which makes sense. Therefore, they have restructured the pre- and post-license education for the broker licensees. And what has resulted has been a change from the 90-hour pre-license and 30-hour post-license requirement to 75 hours of pre-license and 45 hours of post-license. Post equals 3 15-hour courses with a 50-question test at the end of each course. Under Section 550, subparagraph B, number 1 is applied brokerage principles, number 2 is risk management and discipline, and number 3 is transactional issues.
Also, as we film these episodes, we're right in the midst of broker renewal. So we thought it important in this section to take a minute and talk about the transition and how brokers, depending on when they got their license, can renew and what they will need in order to renew based on new provisions in the rewritten RELA or License Act. For brokers who must renew by April 30, 2020, there are 4 different buckets. The first bucket is for those brokers licensed before February 1, 2018. Those folks will need 12 hours of CE, so 4 core and 8 elective, 1 hour now required of all licensees of sexual harassment prevention training. So that hour can be taken as part of a package or can be taken separately. It is not an additional hour, so you only owe 12 hours altogether of continuing education. If you got your license before June 30th, 2019, you could have already taken what was then known as Core A and Core B courses. Those will still count. So you may have like a 6 and 6, where you have 6 hours of core and then 6 hours of elective. If you got your license prior to June 30th, 2019, that will work for you. Otherwise, it's 4 core and 8 elective to make 12. One of the electives should be sexual harassment prevention training. For the second group of brokers licensed between February 2018 and August 8, 2019, which is the day before the new RELA became effective, this is your requirement. 30 hours of broker post-license education and 1 hour of sexual harassment prevention training, or SHPT, which can be included in your 30 hours post, or you can take it separately. It does not increase the hours that you need to renew. If you're in the third bucket, you're a broker licensed between August 9, 2019, the effective date of the new rewritten RELA, and November 1, 2019. Long way to explain that. Bottom line is, you've got, if you're a new broker and you've gotten your license 6 months prior to the next broker renewal date, you will honestly get 2.5 years to complete your 45-hour now broker post-license education. So if you're one of the relatively few that's in that bucket that got your license between August 9 and November 1 of last year, you will, under the Act, be required to do the 45-hour post-license prior to April 30, 2020, by the letter of the law. Here's the rub. There's no 45-hour course yet available on the market. We have been advised by the Division of Real Estate that on a case-by-case basis, those folks should keep watching as to when those courses will become available, and when they are, take them. But if you're in an area where there is no course available, we have heard anecdotally that the department will give a grace period, if you will, for getting that post-license education completed. Obviously, you've got to have a course to take in order to complete it, but the lawyers have determined that legally, under the law, the 45-hour post-license is what will be required of those brokers that are in that bucket just between August 9 and November 1. So the advice would be submit the application for renewal and keep watching for the courses to become available. And as soon as you see a course available, get started on your 3 15-hour modules. If you are licensed on or after November 2nd, 2019, you will owe the new 45-hour post-license on or before April 30, 2022. And when your license issued, when your license, the paper license won't issue, but when your status appears on the DRE registry, your renewal date will be April 30, 2022. In all of these situations, everybody will need 1 hour of SHPT, which has been attached to the 45-hour curriculum. So that would be taken care of if that's the only education that you as a licensee need to do before you renew your license.
Under the new RELA provisions, there have been some changes to the continuing education requirements. Betsy alluded to this earlier. There have been some additional classes added under Section 5-70. The new subjects that are required are transactional management, broker supervisions and managing broker responsibilities, professional conduct, and use of technology. Now you can do up to 12 hours in one day, depending on the format that your education is being delivered in. Also, your continuing education can be completed in 1 hour or 50 minutes for a continuing education credit. Now, for your online classes, they've made some changes with respect to those polling questions where you're acknowledging that you're completing a webinar. Now those polling questions will come up every 50 minutes rather than every 30 minutes. Instructors also have new requirements, and there are significant changes. Pre-licensed instructors can teach pre, post, core, and elective continuing education classes. CE instructors can only teach elective CE courses. So if you want to teach core continuing education, you must be a licensed, pre-licensed instructor.
Some of the other changes with regard to continuing education are centered around a person's failure to do continuing education and what happens then. Under prior iterations of the Act, continuing education that wasn't completed automatically became a disciplinary matter. The department has tried to make CE and failure to complete CE in a timely manner. Yes, it's still a problem, but it won't be necessarily a disciplinary matter. And here's how the changes are set forth in the License Act. The department created a citation program, if you will. It's created under Section 20-20.1 of the Act. And the idea, as I understand it, is to allow for renewal of a person's license even if they haven't yet completed their CE, in which case there's an ability, they'll receive a citation, they'll know that they haven't completed their CE, and then there's a process by which they can complete the CE late and pay a fine or a fee, but move on without having to appear before a disciplinary body. Now, if a person has conduct that is egregiously bad or simply not doing their CE and doesn't intend to do their CE, then that person is going to be subject to regular discipline, and a citation program won't be what works for that person. There are now rules proposed for a citation program under the statutory authority for this to happen. The rules, if you can prove, if you're a licensee, you've renewed, but the department doesn't have on record that you have completed CE, but you can prove that you did timely fulfill your CE requirement, you'll move on. If the licensee can't or didn't certify CE completion, then they need to do their CE within 60 days of citation, pay the fine, and file proof of the late completion. Finally, if the licensee fails to respond to service of a citation, then they need to provide proof of CE completion and fine within 60 days, and the license will remain inactive, so you can't do anything at all during that period of time until all the requirements are met. The last provision, I like to call the liar provision, is if the licensee certified completion but did not do CE at all. In that case, that person will be subject to the disciplinary procedure, having not done CE and telling the department that they did do CE.
RELA provisions have also made some changes with respect to management and oversight. First, with respect to managing broker requirements. The minimum age to be a managing broker has been changed to 20 years old. And now you must have been licensed for 2 consecutive years of the past 3 years. Also, there have been some changes with respect to the designated managing broker responsibilities. This has happened in Section 10-55A, and that is a great section to actually read word for word because it outlines word for word some of these changes and these new responsibilities. Essentially, 10-55A outlines the basic and existing rules for oversight. Now, a designated managing broker is responsible for the policy implementation in the brokerage branches or virtual offices or anything operating under the sponsoring broker. They are also responsible for all training of the licensees that are associated with the sponsoring broker. They are also responsible for all oversight of all special accounts of the company.
So as Annalise just explained to you, the designated managing broker has some very specific oversight responsibilities, and those contained in subsection A were already there but not in statute. They were there in the rules. And so now they're in statute, so they're very clearly set forth there in the Act where you can go and read them. So she's absolutely right about that. Another provision in 10-55 is in subparagraph B. Subparagraph B includes what the designated managing broker responsibilities are with regard to oversight of new broker licensees. So as we've explained before, the new broker licensee, the theory being that that person would take the 75 hours, get their license, and then get out into the real world, all the while studying, learning in real life, studying for and taking their 50-question tests at the end of their 3 15-hour courses. While they are doing this, and before they have passed all 3 or the 45-hour broker post-license education, that designated managing broker has very, very specific oversight responsibilities. In other words, the designated managing broker must oversee all handling of earnest money. So that is specifically in the Act in that subparagraph. Also incumbent on the designated managing broker is the oversight of contract negotiation. So that designated managing broker has to somehow be involved in the process. I would submit that there's a way, if you are doing electronic negotiations, that that designated managing broker be somewhere in the loop of the electronic communications. That might be a way that the designated managing broker can prove that he or she is overseeing the negotiations and involved. Finally, the new broker that hasn't yet passed the 45-hour broker post-license requirements cannot bind the company in any contractual relationship. So that would be also a responsibility of that new broker's designated managing broker. So there are proposed rules to further put flesh on the bones, if you will, of the requirements for the designated managing broker to oversee those new brokers. Regarding handling of earnest money, the designated managing broker, this is proposed rules language that I'm just going to read to you so I know that we get it right. The designated managing broker must have an established procedure for delivery of earnest money from the new broker licensee to the designated managing broker for proper handling pursuant to the rule provision with regard to any special account. Most typically that's escrow money in a contract, in a sale contract, or even security deposits if you're talking about a leasing situation. Or when the earnest money is paid electronically, the designated managing broker shall be directly responsible for handling and oversight of transferred funds in accordance with the language in the escrow rule, which for those of you that are going to go read it, once it's available, it should be in section 1450.750. Finally, the designated managing broker should be able to demonstrate the designated managing broker's oversight and handling in a manner that shows control. So just for example, even where functions are delegated to a bookkeeper, the designated managing broker should be able to show his or her involvement, review of the books, process that oversees the handling of that money from the new broker to the sponsoring broker's escrow account. On the next episode of Illinois Realtors RELA web series, Annalise and I will be covering teams and advertising. Be sure to watch.